kind of robot. I think you've got to. If you were a non-legal arbitrator, a legally qualified arbitrator, it might be different. But I think if you are legally qualified and you're in a position to make some sort of judgment on the basis of your own experience, then you need to do that. But it's not only in cases where you may know of a case, or you may turn up a case that you think may have some influence on this thing, but also if there is something from your own experience, you may have some expertise in a particular area and the experts have not covered it or whatever. You should obviously not rely on your own expertise unless the parties have some opportunity, possibly the experts, to comment on the point that you're trying to make.
All right, so let's say you do go back to them and then they come back to you and say, yes, we know that's what the law says, but neither of us actually likes the fact that the law says that. And so what we'd like you to do is deliver your decision as though the law said this.
Well, I think I would have to say in my award that I believe that what I consider to be the outcome of the case on the basis of the proper interpretation of the law, and say that the parties have, by consent if necessary, agreed that the outcome of the arbitration should be X, notwithstanding the what I consider to be the correct interpretation of the law. Because, it is a consensual process at the end of the day, and if the parties, for example, if they agreed to settle the case, leaving aside any legal principles which were involved, they're perfectly entitled to do that. But I don't know. The case has certainly never arisen in any case involved in, but that would be my answer.
So you think as long as you can sort of be clear, you don't want people reading this and thinking, wow, Ian's an idiot. He has no idea how the law works.
No. Well, of course, it's supposed to be confidential. But
things do come out there. So.
Yeah.
Alright, okay, so would it matter on what the law was that they were trying to avoid? That sometimes there's a mandatory law, for example, or even a public policy thing.
Yeah, that can be more difficult. But it may then be a question of law. If you're being asked to deal with something on the basis of English law, then you may have to look into the question of how does English law deal with foreign public policy, for example, or international public policy. I have this in cases involving backdating of contracts, for example. So a contract's governed by English law and the parties decide to backdate it deliberately in order to try to get around some regulation which would be applicable if the contract was dated the true date of signature. And it's quite, I think, uncertain as to quite what the position would be under English law now, because there are cases back in the 1930s which say that if you have a transaction structured so as to deceive, whether it actually succeeds in deceiving anybody or not is irrelevant, but it will be treated as being illegal and unenforceable. But more recently, the Supreme Court, I think, in this Patel and Mirza case, has adopted a rather more sort of soft approach, nuanced approach, put it that way, to cases involving illegality. But what I'm getting at is that these are cases really involving foreign illegality, or the deceiving of a foreign body like a flag authority, a foreign insurer, or something like that. But what one would be having to look at would be the understanding of what the English law was in relation to things which infringe foreign public policy. So it would be really interpreting English law still.
Okay. And now, are all the things that you get through the LMA, they're always English law?
Yeah.
Okay.
But almost always. I think I've had one case out of hundreds which involved Italian law, I think, where the law was to be proved. Well, it's either proved as a matter of fact, or you assume that it's the same as English law.
I always like when I see that.
Yeah.
This thing that patently is nothing like English law, let's just assume it's exactly the same.
Yeah. Well, I've had a couple of cases actually which have involved aspects of the case which have been, say, subject to Chinese law, as for example, whether a ship could be leave Chinese territorial waters without having a specific export license or something of that kind, and therefore heard Chinese legal experts on both sides saying Chinese law says white, and the other one saying Chinese law says black.
Yeah.
But so you've got to make some decision on that. So that happens, but it's in relation to subsidiary issues, and the fundamental substantive law of the contract will almost invariably be English.
Okay. Right. And so I don't know how it's probably not likely to come under English law. So just for the sake of this one part of it, just imagine you're dealing with some other kind of law. Would it matter the nature of the mandatory law? Because there are countries, for example, where certainly there are serious public policy things, but there are some countries that have much more trivial things. So they still say this is a mandatory law, but it's not really objectively that big a deal. It's just something.
I think you'd have to refer to English conflict of law principles, essentially, and again look at what does English law say in relation to the performance of contracts which infringe a foreign law.
Okay.
And I mean, frequently, particularly if it's a tax statute, then English law will say, "Well, bugger that, we don't take any notice of it," or something. But there have been cases recently. I wasn't particularly involved in them, but I do know of them. For example, where Mexico has suddenly said, "We forbid cases of this kind to be dealt with in arbitration," or things like that. I think I have had one similar to that, in fact. And I think we follow what we understand to be English law and the principles which we've adopted by the English courts in interpreting contracts and that sort of situation.
All right. Have you ever written a dissent?
No.
I take it that's not a self-conscious thing in the sense of you haven't. Okay, so there are people I know that would just say, like, I will literally never write a dissent because they just don't believe in it.
No, I would if I have.
Okay, so what do you have a sense of what would get you to the point of writing a dissent?
Well, if I thought that if there were two interpretations of a legal principle or as applied to the particular facts of the case, and I thought that the other arbitrators had having decided in one way, I would decide the case differently, and I would. I mean, I wouldn't say on the point of doing that because we've normally sort of rationalised our differences, but I can imagine circumstances in which I would do.
Okay, so if it was something that would influence the outcome, then that would be enough for you think?
Yes, well, I suppose it wouldn't influence the outcome, except insofar as if they went to appeal, and to some extent the view of the dissenting arbitrator was taken into account by the appellate court. But the appellate court would usually make its own mind up. When I said influence
the outcome, I meant in the sense of if everyone agreed with you, it would come out this way, whereas the majority is actually going that way. Yeah. So in that situation, you would be willing to write a dissent because you thought they were just wrong.
Yeah.
Okay.
Yeah.
All right. I had a follow-up. No, I've lost it while I was going there. Alright, well, we'll assume that it wasn't a good follow-up then. Alright. Okay, so the next one is... You're a member of a 3-person tribunal in an institutional arbitration appointed by the claimant. The Respondents' Council has brought several increasingly serious challenges against the tribunal chair. Each challenge has been rejected by the institution, but the Respondents' Council keeps making them and has escalated by discussing the challenges with Global Arbitration Review, which published a lead story on them. Assume that there's no confidentiality in the arbitration.
Right.
Then, by coincidence, you overhear a phone call in which the challenged arbitrator is repeatedly swearing and cursing about the council bringing the challenges, complaining the publicity has ruined his reputation as an arbitrator. He ends the call with, "Don't worry, he'll get what he's earned," although you can't tell from the context what that comment means. So what would you do?
I think I'd write to the institution.
Okay.
The institution is responsible for, generally speaking, for the appointment of the arbitrator in the first instance for deciding whether they should continue. And ultimately, obviously, the court has a jurisdiction in it if the arbitrator is rightly accused of actual or even apparent bias. But I think in the first instance I would write to the institution.
Okay, so you wouldn't talk to them first, or to your other arbitrator. Okay.